Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is a time set for oral argument in State of Arizona versus DDT Devco 6 LLC. Our case number CV130721. Each side is allocated 20 minutes for oral argument. Appellant, you may reserve a portion of your time if you wish to for rebuttal. If you want to do that, you'll need to keep track of your own time at the clock on the podium. Out of respect for counsel, I would ask that those in attendance make sure that their telephones are off so our arguments are not interrupted. We have reviewed the briefs. We've conferenced the case this morning. We encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted to YouTube in due course. As you begin your argument, please state your name and the party that you represent, if you would. With that, Mr. Hirsch, you may begin.
May it please the court. Good morning. My name is Steve Hirsch from the firm of Brian Cave. With me is co-counsel Rodney Ott. We are here for appellant and property owner DTD Devco 7 LLC. With the court's permission, and we'll see how it goes, I'd like to preserve 5 minutes for rebuttal. And as Judge Thumb has indicated, sometimes that's doable, sometimes it isn't, but I'll try to keep an eye on the clock. The briefs have stated, as your honors have seen, 5 reasons why we feel this property owner should not be precluded from presenting its evidence of just compensation, and why this summary judgment motion should be reversed. Those 5 reasons can be grouped to 2 standards of review as we see it. 2 of them are under a de novo standard, and 3 of them are under an abuse of discretion standard. We feel the record is quite strong that under both standards of review, under all of the issues stated, that this summary judgment was improvidently granted. Although we're aware of the distinction between the grant of a summary judgment and a sanction, this operated as a sanction. It only existed as a judgment because of the sanction entered precluding the material issues of fact that were disclosed untimely. And that in this case, if you will, boiled down simplistically, the punishment to this property owner does not fit the crime of the delay in disclosing under the court's initial schedule here. I won't belabor the panel with the facts, although we can go through those if you wish. The fact is here, and it's uncontested, this was a condemnation case. The state, after some assistance from the property owner, achieved immediate possession. So from a prejudice standpoint, which is one of the glass lenses that the panel should look at this through, the state had possession. This is the Loop 303 out on the west side in the city of Glendale. The state had possession, and its box was checked off in terms of being able to proceed with its construction. The case then turns to the property owner getting its case ready. And as the facts show, one of the issues that come up in these more complex condemnation cases, and here we had a pair of cases filed at the same time involving the same property, one slice owned by Walmart and one slice that's before you owned by DTT Devco, had some issues that included some developability in the after situation issues, and that's what took the time. This is not one of the cases that we see in the books, say a personal injury case, where counsel are lax or ignoring the case, letting it sit. These were active discussions. They're detailed in the record. They're detailed in our moving papers before, and the trial court just chose to give that no weight whatsoever.
Counsel, that being said, I mean, there was a clear discovery order entered with the deadlines that said that these are the deadlines for disclosure of experts, and these will not be extended absent good cause. So how do you explain the failure to notify or to designate an expert?
Sure. Judge Brown, I decided to argue this case as the lawyer who did these acts and inactions below, rather than having a third-party attorney here before you. The issue here before you, we would contend, is whether the punishment fits the crime. I did not.
But I think that the problem that I'm struggling with is that, I mean, there is a discovery order. The court found that your disclosure was untimely, And that's an abuse of discretion standard, is it not?
As to that particular issue, the failure, which is one of our points on appeal, to continue to grant our motion to continue the disclosure deadlines, that is an abuse of discretion. And I'll explain to you why we feel discretion was abused in that case. But we've set forth on the record the reasons why this case was being diligently prosecuted, and it was being diligently prosecuted and issues were still being decided even while the clock was ticking on the motion for summary judgment. A severance issue was negotiated away, and the issues in the case were thereby narrowed. We secured the disclaimer of co-defendant City of Glendale. So as we got ready to tee the case up for discovery and to determine if indeed we even had a case that it couldn't be settled, Glendale was out of the way. Right on the eve of oral argument in April, Wells Fargo, the lender here, reached its agreement with DTD Devco and disclaimed. So I want to make the point, and it's in the record and was explained to the trial court below, that this wasn't a case of just ignorance or deliberate disregard of the rules. If I could set back the clock, would I have filed the motion? Yes, Judge Brown, there's no question about it. There's a 30-year track record with litigating with this agency and with the management of this agency. Some of these folks I've worked with since the early 1980s are in the room today, and there was a misplaced trust that this case would either be settled or, as the other one was, and this is property 1 inch away from this property, settled. This wasn't. And in our respectful view, this is a case that lines up with the Allstate Insurance versus O'Toole case, which is the 1995 case that was kind of the first oracle from on high by the Arizona Supreme Court when Rule 26.1 came out. And predictably, counsel started to use it as a sword rather than a disclosure device. And it was the first case that really addressed whether disclosure untimeliness in a setting of no real prejudice, which we contend is the case here, could justify a dismissal of the case. And as the Arizona Supreme Court said in O'Toole, it is not a trap for the unwary. And the disclosure rules are not meant to thwart the goal of maximizing the likelihood of a decision on the merits. And that's really why we're here on appeal before you, is that the trial court here, by its actions, given a clear violation of an initial scheduling order, eliminated any trial on the merits of this case by the heaviest sanction imaginable, which is saying to the property owner, you do not get to put on your case of any money above and beyond the initial conservative appraisal that ADOT feels this property is worth. And O'Toole speaks to to discouraging litigants to seize upon transgressions to get a case dismissed. And really that's what happened here. This is tantamount to a dismissal of the case. Now let's get back to the de novo standard and look at the DeLong case. You know, many times we stand before you, particularly on issues like this, and we're not benefited by Arizona case law. Here we have a couple of cases that are pretty close. One supporting a reversal of summary judgment, which we contend should happen here, and that's the DeLong v. Merrill case. And another one that affirmed a trial court's grant of summary judgment. That's what the state predictably relies upon, and that's Tilley, Tilley versus Delsey. These are the two cases we'd urge you to focus on in determining the issues on appeal. But even Tilley is instructive to the panel under the facts of this case, and even Tilley supports a denial of this on the de novo denial and a reversal of this motion for summary judgment on grounds that material facts were set forth in the record. DeLong, of course, is the case where the transgression, the failure, was something we contend arguably is more serious and substantive than the failure to meet the initial scheduling order here, and that was not timely answering Rule 36 motions for admission. And a request to admit, I should say. And there they went to the substantive heart of the case. The party did not answer them, and summary judgment was granted on the basis of the admitted facts. Now, the appellate court reversed, and the appellate court looked at two issues which we think drive the appeal in this case, and we think this panel should respect in analyzing the facts. First is the importance of having an action resolved on the merits. Again, echoes of O'Toole from 1995. Secondly, the weighing of prejudice to the opposing party. The trial court here didn't do any of that, and the briefing below and the appellate briefing before you by the state doesn't mention any prejudice, and it can't other than delay. And we see in the cases, including Tilley, that delay alone is not prejudice. You have to show some substantive prejudice. Here we had a case that was filed, the state got possession. All that's left is to set just compensation for DTT Devco, our client. The only prejudice here to delay is the deferral of receipt of full, fair, and just compensation to the property owner. Okay, the property owner here preferred to harmonize the issues in the case and zero in on what the scope of the case would be so we could determine whether or not it was going to be settled, as the parallel case was, and if it was needed to hire an appraiser to counter the state's number. And we felt the response to the motion for summary judgment would be a notice of settlement, okay, but it wasn't. And violations of the scheduling order undoubtedly occurred, but the issue is whether a dismissal of the case is justified under those circumstances, and DeLong stands for the point that it is not, because there's no prejudice to the state.
Councilor, can you help me understand how you were deprived from the opportunity to present a genuine issue of material fact?
Sure.
In the summary judgment.
When it became clear that the state settling in one breath the immediately adjoining parcel, okay, 1 inch away, would not settle this one and would instead, we would contend, seize upon the technicality, because they had in their hand an argument that an expert hadn't timely been disclosed. The property owner disclosed. Okay, this is the February 26th filing that's in the record. Okay, 3 fact issues precluding summary judgment. And the trial court just erred on this point by not even addressing some of them. And that's what DeLong, we contend, compels a reversal of judgment here.
And one of those issues, if I just cut to the...
Yes.
I know you're going to run out of time here, but Mr. Elbogen, is that...
Elbogen, yes.
Elbogen?
Gary Elbogen.
How was he qualified to testify?
All right.
I mean, without going outside the record, I guess I'd like to know who he is, I mean, according to the record, who he is, and how he has authority to testify on behalf of the owner, or if he is an owner. Yes.
DTT Devco LLC is an LLC. Mr. Elbogen, let's stick to the record, was listed as the authorized agent of DTT Devco LLC. The standard here, we're not before you weighing a thorough record and a preliminary evidentiary hearing.
Understood. I mean, but okay, let's assume, okay, you've asserted authorized agent. Are you aware of any authority in Arizona or throughout the country that says that an authorized agent can testify in a condemnation proceeding on behalf of the property owner?
Your Honor, respectfully, who else do you have for an LLC?
Well, I'm just wondering if there's any authority out there.
Yeah. Well, in terms of, this is one of 3 material issues of fact, mind you. The other 2 are clearly in the record, and I'll touch on those in a minute. But in terms of the owner's opinion of value, we would rely on the long line of Arizona case law that we stated, none of which specifically address the issue of whether being an authorized agent is enough. But when the owner discloses that its authorized agent and mouthpiece as a business LLC, and in this case a conglomeration of investments into real property, is the real estate development manager as its authorized agent, doesn't state that, but that's why it's the authorized agent, that is enough to defeat summary judgment. That is enough in our view under the standards of O'Toole and the weighing of prejudice and the zeal to the importance of having a matter resolved on the merits. But let's move on to an area that isn't in dispute. And by the way, we would contend the judge bent over backwards below to try to exclude that owner's opinion of value because he recognized under DeLong, we would observe, that it was a material issue of fact that precluded summary judgment. What about using the state's own expert, who was disclosed as being subject to being called in the disclosure statement that was late filed? We try these cases all the time because you can't recover your fees, either attorney's fees or expert witness fees, even if you win these condemnation cases, on appraisals of the condemning authority. Mr. Worth's appraisal was clearly known to ADOT. There's no disclosure violation there. It is the highest height of technicality to say, well, you didn't say you would be calling Worth and give me a paragraph of what Worth has to say when it's the state's own appraisal. Worth's appraisal, as the record shows, has 5 comparable sales that contain values that support up to $4.50 per square foot, which is above the state's number, which was $3.75. So it is untimely disclosed, but disclosed. Okay, again, punishment fitting the crime, the Mark Worth appraisal and the comps within that appraisal, all of which come in under Town of Williams versus Perrin. The other issue that is a material issue of fact, suggesting that the $3.75 should be weighed by an Arizona jury in terms of just compensation, is the original price paid by the property owner. That's in the Worth appraisal and it's in the disclosure statement of $5.50 for this parcel out on the Loop 303, and the price that Walmart carved out the front pad for on a discount basis at $4.41 to attract and lure Walmart as the anchor developer of this parcel, a loss leader, if you will. That was disclosed untimely, and the test is whether it was an abuse of discretion to deny it. Now, I'm down to the 4-minute mark. I'll just close with this point on abuse of discretion. The panel is well familiar with the standards there. We're aware that a grant of summary judgment is not a sanction, but our point is that the grant of summary judgment would not have occurred here without the sanction of excluding the owner's opinion, the Worth appraisal, the ability to cross-ex Mr. Worth, the ability to bring in the original cost very recently, comparatively, of the property, the ability to bring in the price at which Walmart in the open market paid for its carved out parcel, again, pretty proximate in time. The case law tells us if there's any doubt as to whether an issue of material fact exists, summary judgment is appropriate. But for the extremely burdensome and onerous and disproportional sanction of locking this property owner out of court for the transgressions of yours truly in not filing a few weeks earlier a motion to continue things, continue the deadlines, this property owner, we think, constitutionally has been foreclosed of its right to a jury to decide just compensation. I'll reserve the remainder of my time, if I may.
Thank you, Counsel. Ms. Moinkemmer.
May it please the court, my name is Adrienne Weinkammer. Sitting at the table next to me is my co-counsel, Jennifer Dorsey. We represent the state of Arizona, the Arizona Department of Transportation. I'd like to refocus this discussion on the standard at issue in this case, which is the standard that applies to summary judgment. Summary judgment is appropriate when the record shows there is no dispute as to any material fact. ADOT made this showing and proved to the trial court it was entitled to judgment as a matter of law. It made this showing by providing evidence of just compensation that was due to the property owner, which was the only remaining issue in dispute that would be before a jury in this case. We pointed out to the trial court that the burden of proof to prove just compensation is on the property owner in this type of litigation. And as such, a property owner would have to put on their case first to the jury. The only valuation evidence relevant to just compensation was produced by ADOT. Now, Rule 56 is very clear that a party opposing a motion for summary judgment cannot rely merely on denials. They must point out specific facts that are in dispute in order to overcome their burden of proving that a factual issue is in dispute before the trial judge. If the opposing party fails to do this, summary judgment is appropriate if the party is entitled to it as a matter of law, as ADOT was in this case. While much has been made of the untimely disclosure, I would argue to you today that the untimeliness of it, which it was untimely, and the egregiousness of the behavior of the defendant, which it was, is not really the issue here. The issue is what was before the trial court that created a disputed fact that he could rely on in finding summary judgment was not appropriate.
But if the court had extended the deadline for disclosure of expert witnesses, then you wouldn't have been able to file your motion.
The request for the extension of deadlines was contained in the defendant's response to our motion for summary judgment. And as such, although it was titled a response for an extension of deadlines, it really functioned as a request for 56F relief, an additional time to find evidence which could support a disputed fact to the trial court. And that's how the trial court viewed it. But
it didn't have an affidavit.
There was no affidavit in support of a Rule 56F hearing or 56F relief. That is true. The court still chose to view it that way because at that point in the process, once the motion was filed, there were only a few mechanisms left in order to support the extension or the new deadlines. They could rely on 56F, which they could argue allowed them additional time to come up with evidence that could dispute the valuation that ADOT had put forward. But even that standard, the Rule 56F standard, was not met by DTD DevCo.
Well, but they didn't rely on Rule 56F, and the request doesn't look like a Rule 56F request.
It does not.
It looks like a Rule 6 request for extension of time, which would require good cause and excusable neglect. Does the record show that the trial court applied that standard?
I believe that during the briefing and during the oral argument that took place before the trial court evaluated good cause associated with granting an extension of deadlines. I believe that is true. The good cause set forth by DTD DevCo was deemed inadequate for a couple of reasons. DTD DevCo admits it violated the court order, and it admits that the reason it did this was because DTD felt they could settle the lawsuit without having to spend money on acquiring any evidence. The key point in this case is many months earlier, DTD DevCo stipulated to a scheduling order before the trial court and said that all evidence would be produced prior to any settlement negotiations. And as the deadlines continued to come and go, ADOT attempted to contact DTD DevCo and say, where's disclosure? What's the status? Where are we? With no communication. Now, they admit that their purpose was the hope of settlement, which case law very clearly states does not constitute good cause. By that admission, ADOT would argue that the violation of that court order was purposeful. And when that court order was entered into and stipulated to by DTD DevCo, there was really no intention of following it. DTD DevCo had their own plan on how they wanted this case to go, and they kept the trial court and ADOT in the dark.
Counsel, let me ask you, you have mentioned it is in a condemnation case, it's a landowner's obligation to show just compensation, the burden of proof, if you will. Fair?
Yes.
What if instead of the timely worth disclosure, the state offered no expert disclosure and then moved for summary judgment? You filed the same motion, recognizing it is the landowner's burden to show that there's a disputed issue of fact. Would you be making the same argument?
I don't believe so, because I think
In other words, I'm trying to figure out why is it the fact that the worth disclosure was timely made matters?
Okay.
If it's the landowner's obligation to show the amount of just compensation.
Okay. The Arizona Constitution is very clear the property owners are entitled to just compensation. The state of Arizona is acquiring property by which it must pay just compensation. During the administrative process before cases are filed, ADOT is required to have an appraisal prepared, produce that appraisal, make a good faith offer based on an appraisal. So an appraisal exists. Then the law also says that the date of value is the date of the summons and complaint in most cases. So ADOT will have an updated appraisal made and a new offer made once that case has been filed. So there is always evidence of value on ADOT's part. ADOT cannot proceed with acquisition without providing an appraisal or having an appraisal prepared. I think that the distinction in this case is that Arizona law also says that a jury in a condemnation matter can only find within the range of testimony. And so the argument is that if there's only one set of valuation testimony, coupled with the very clear line of Arizona cases that says you cannot overcome your burden on summary judgment by just saying, well, uncontroverted testimony will be disbelieved at trial, just give me a chance to get there. There was really only one verdict that the jury could decide, and the assertion that cross-examination would come to any different conclusion isn't sufficient to create a disputed fact.
And I understand that argument. That's a little different, though, than what I'm asking about. Why is the Worth appraiser, why is the number that Worth came to in the judgment? Why is that the proper number if the landowner has the burden?
Well, because Mr. Worth is an expert valuation witness.
Right, but not tendered by the landowner.
No, he's not.
And that's really the root of my question.
So, where I guess how I understand your question is somewhat in light to the idea that the property owner should have some right, constitutional right, to come forth and provide evidence at trial.
It's different than that even.
Okay.
It is, why is the Worth valuation the proper valuation on summary judgment if the reason why summary judgment was offered is because the landowner offered no evidence?
Well, merely because Mr. Worth was hired by the state of Arizona doesn't make his opinion any less valid as an estimate of just compensation. And again, I would point to the fact that the jury can only rely on the testimony before it. So while typically if the jury has many opinions to choose from, they would weigh those many opinions. Under these circumstances, when you couple, like I said, the limitations on the jury, they're limited to testimony, coupled with the fact that summary judgment requires that you create a disputed issue of material fact, and that dispute cannot be based on the hope of cross-examination, you really cannot come to any other result. And while the
Let me then follow up. If your disclosure instead then had no appraisal, no value, and we have otherwise the same record, isn't summary judgment granted and the number's zero? Why is that not the case?
Because if we didn't have an appraisal, Your Honor, there wouldn't be a case pending.
Well, if you didn't disclose an appraisal, and this is a hypothetical. I mean, don't confuse that with this case.
I do.
with this case.
I do understand that, but it is so outside the realm of possibility that I agree.
But-
I don't
but-
think we could. I don't think the court could say zero. But
the result that you're seeking
Mm-hmm.
would imply that would be the result. The result would be zero.
I think the result I am seeking is when there are no disputed factual issues in a condemnation matter, summary judgment can be properly entered. And there is no case law that says that under the circumstances of a condemnation matter, summary judgment is never appropriate if a property owner is not allowed to testify. And in fact, part of our briefing pointed to a specific case, the Choicer case, in which a property owner's disclosure was inadequate. A bit different. The inadequacies are different than the inadequacies here, but deemed inadequate nonetheless. She was not allowed to go and testify, and summary judgment was entered on behalf of the condemning authority and upheld.
What is the standard for an individual? There's a you could call it a quirk or a unique rule that a landowner gets to testify what they think the property's worth.
Yes.
And that's subject to cross-examination, subject to contrary expert testimony, subject to a whole bunch of things. But it's kind of a unique aspect of condemnation meets evidence law.
It is.
What is the standard when instead of an individual, the landowner is an entity?
Well, I think that Judge Brown pointed out that there really is no case law on that. I think that you look to knowledge, personal knowledge. You look to...
Is that required for an individual owner, personal knowledge? In other words, if I live on the other side of the world, have never seen the property, I buy it the day before the valuation date, and then I want to come in to testify, don't I get to do that?
I think you have a pretty good argument that you would be able to get to do that, yes.
Right. And how, so, and I interrupted you, but it strikes me that it's something maybe a little different
It
than
is a quirky area of the law where there is no case law that really details the standards for how somebody is authorized for a corporate entity. What I would say is that while, even if you were to, on appearance of the disclosure statement, say, it really appears as if this gentleman could satisfy whatever standard there might be, if we had made that argument and put that to one side, I would again point back to there was no avowal to the court that the statements contained in that disclosure statement were true facts. So,
Well, doesn't the verification, though, comply with ADI? I mean, which you can use for affidavits. I mean, it looks to me like it's patterned after ADI.
well, verifications and affidavits function differently. So in a verification of a disclosure statement, you're verifying that it is true and correct that those individuals are going to testify in the manner that they are listed. So, for example, if you have multiple witnesses in a disclosure statement and the party verifies it,
Sure.
they certainly aren't verifying that what those other witnesses are saying are true and correct. They're verifying that's what they are going to say.
I understand that, although here we have the verification signed by the same individual who was purporting to be able to give testimony about value. Fair? So the hypo you paint is, I think, true, but it's not applicable here.
Well, I think it is applicable because similarly, the individual who is verifying the statement that he is the authorized agent is only verifying that he's going to testify in that manner. And you still have an obligation in accordance with Rule 56 to oppose the affidavits in a response for a motion for summary judgment with either affidavits, interrogatories, deposition transcripts, or other materials that could be admissible in evidence. And until you have some sort of authentication document, such as an affidavit, to support what he discloses, you really can't get over that hurdle to say this. You don't have the appearance of truthfulness where the trial court could say, okay, this testimony, first, the disclosure statement wouldn't be admissible. It's the testimony that would be admissible. So you're attaching a document, it wouldn't be admissible in court. So you need to have something else in order to prove that that testimony itself would be admissible in court.
Let me ask you about that, and I'm just reading out of ADI, and that, remember, talks about certifications as well as affidavits. I declare, certify, verify, or state, under penalty of perjury, that the foregoing is true and correct, executed on. I think, by memory at least, the 26-1 verification complies with that. Do you agree?
Yes, to my memory, it's verbatim.
Well, yeah, I mean, some of the optional language is excluded. But you're saying, and that says, hey, that's sufficient for an affidavit, as well as other certifications. But you're saying there's sort of something more that would be needed for him to be able to testify. I'll call it from an evidentiary perspective. Let's set aside timing from an evidentiary perspective. What is that something more?
Well, I think that what's lacking in this case is an accompanying affidavit to support the foundation for the admissibility of that testimony. Like I said, that the disclosure statement itself is merely a document.
What would that look like?
It would be an affidavit where he would swear under penalty of perjury that he is who he says he is, what his relationship is, what his opinions are, what those are based on, and everything that you would need in order to testify at trial.
Let me ask, what of that is lacking from your perspective?
I think that his disclosure statement, first of all, is merely a disclosure of what he's going to talk about. He doesn't say what he's authorized to do, what his scope of authorization is, what his relationship is to the company, the basis for his opinions, and it's only it's a paragraph that says, I'm going to testify to this. It is not the same.
And I understand your point on how he's authorized to, he's an agent or whatever in the corporate realm. But if we use as an analog, and we I think are on the same page, that there isn't either case law or robust case law on who can speak for a corporation to valuation as a corporation, what more did he need to provide other than the number? If Sam Thumma, as a landowner, individually can say, here's my number, and on cross-examination, I'm asked, what's the basis of your number? And the answer is, I don't know, but I've lived here for a long time, and
Yes.
I like my house. I mean, that
Wait,
probably
yes.
comes in.
Yes.
In the corporate setting, how is it so different that he would have had to provide the foundation or the documents he relied on as a matter of 56E admissibility?
Okay. Well, I think that because there is a differentiation, this is a corporate entity versus an individual, I think that he, at very minimum, needs to provide this, an avowal to the court that he's authorized to bind that entity.
And I
okay?
understand that. Let's
One.
set that aside.
Yes.
The other was what additional
Once-
basis?
Yes, once you get over that, I think that he can give his opinion of value. And I think that according to Rule 56, which says that any materials or information you're going to rely on in an affidavit, such as, okay, the sale of the property was this, then you need to point to some sort of documentary evidence of that, which was not done.
Well, but what if the answer is, well, I don't have any of that? I'm going to get up, I'm going to say who I am, who I work for, and here's the number, and then it will look for cross-examination.
That's not all that he says. He says here, if under a hypothetical situation, if he said, this is my name, this is my scope, this is where my scope is granted, I have the scope to bind the company, this is my number, then it may be a different circumstance, and the trial court may look at it from a different angle. I don't want to stand in his place, but I will say that that's not what happened. And so while there are many, it really boils down to this. In Rule 56, you do not need to allocate blame between attorney and client, period. So while the attorney would like to say I made mistakes, I didn't have everything in there that I should have had, I should have done this earlier, whatever. Rule 56, blame between attorney and client is not a part of that. It is about disputed facts.
Is prejudice a part of our analysis or not?
I think that I'd like to clarify a little bit on prejudice. I think that in Rule 56, it is about facts in dispute. I think in this case, because there was, however you want to term it, request for Rule 56F relief or a request for an extension of deadlines, the claim has been the state suffers no prejudice and has never made such claim, which is inaccurate. In our argument that was discussed at length.
What is your prejudice?
Our prejudice and our argued prejudice is that the state of Arizona is required to pay statutory interest, so we have monetary prejudice. The longer these cases extend, the more money ADOT has to pay at the end of the case. So we have an interest in efficiency.
Well, what about the fact that a sanction could have been, well, they're not going to get any interest from this point to this point, until they disclose their expert. I know we've run out of time, but.
Do you mind 2 more minutes per
Oh, yeah, a
side?
couple, yeah.
We'll grant each side 2 additional minutes.
Which, just to follow up, if you could address, following up on that, the ability of the court to, or whether the court should have imposed or considered at least some lesser sanctions, attorney's fees, pursuant to a sanction the other side, eliminate interest, maybe
Okay.
put a cap on damages. I mean, I think there would be some creative ways to possibly look at some other alternatives.
Okay. I'll answer your question about prejudice beyond the statutory interest and then the ability to then maybe fashion a less harsh remedy. There's case law, there's case law on point that says you do not, the trial court in determining Rule 56 motions doesn't have to consider a less harsh remedy. That doesn't mean he was outside of the law when he made the decision that he made. There could be any number of remedies that a trial court has the discretion to enter. There's no disputing that. The trial court, under Rule 56, and Tilly v. Delsey says this very clearly, the trial court does not have to consider a less harsh remedy. That is not that does not defeat this motion. Whether he had the discretion to do so in considering other matters, of course, the trial court has a great deal of discretion. He chose not to exercise it. He had no disputed facts before him. ADOT had a right as a matter of law to judgment. It was well supported by the law, what was in the record, what was properly before the trial court. And, you know, I'll end on this if there are no other questions. I think that this is a case where DTD Devco is trying to shift the blame for their decisions, their inaction, to the trial court and to ADOT. There's no evidence that ADOT was using playing procedural games. We attempted to contact them. We tried to work it out. Silence. There was no other remedy for the state other than to proceed as we proceeded. And there's no evidence that the judge's ruling went outside of the law or what was allowed under Rule 56.
Thank you, Counsel. Mr. Hirsch, rebuttal.
Thank you, Your Honor. I'll make 3 points. After addressing just kind of the closing colloquy there, the only reason that this was a clear motion for summary judgment is that the material facts were excluded by way of a very onerous sanction. Tilly,
But they weren't excluded at the time they filed their motion.
well, they were
There's nothing excluded.
They were excluded because of untimeliness and on the one prong of the witness issue, the owner rep, because of what we feel was a incorrect ruling on authorized agent not being enough to defeat summary judgment. That's the only, I want to draw that distinction, Judge. I don't mean to interrupt you, but in Tilly, the party never put forth any issue of material fact. In DeLong, they did. And in DeLong, the appellate court said, okay, that thwarts the purposes of decisions on the merits for us to uphold a summary judgment based on the fact that you didn't answer Rule 36 request for admission.
But doesn't that distinction presume that the declaration of value on behalf of your client was admissible?
Yes, let me address, that's one of the points I was going to raise because it came up and was part of the dialogue. I didn't pull up on my smartphone because it would probably start beeping and irritate the court, Rule 80I. But my clear recollection of Rule 80I is that it says whenever under these rules an affidavit is called for, a declaration suffices. Rule 56 all the time is responded to properly with declarations as opposed to affidavits. That's the reason for Rule 80I. And the submittal, and I have it here in my hand and it's in the record, of Mr. Elbogan went far beyond, I'm Gary Elbogan and I plan to testify. In his declaration under oath, which the sole flaw of which was untimeliness by a few weeks, but the judge kept it out on that basis, he set forth the original cost of acquisition of the property, which was one of the material issues of fact. You have it open there, Judge. Did I remember it right?
But I know what you're
okay.
speaking of.
The price Walmart paid for its carve-out loss leader corner pad at $441, that comes into evidence and creates a material issue of fact. And his owner's opinion of value with all the math laid out and all of his justification for that opinion set forth, as well as a cost to cure amount, which, by the way, the state, after argument, agreed to and paid as part of the judgment that was entered in the case. You'll see some back and forth after the grant of summary judgment about the form of judgment. The property owner continued to cooperate even after the sanction was entered here to narrow the issues and get that issue taken care of.
But I think, and your point on ADI, even an ADI compliant declaration or affidavit or however you want to title it may not be admissible under 56E if it doesn't contain the information. In other words, if the signature block's right, but it still doesn't contain, that it's based on personal knowledge, set out facts that would be admissible in evidence, and show that the affiant is competent to testify on the matters stated.
Right.
It could be compliant with ADI, but not admissible under 56E.
Well, Judge, remember, though, that the first and prime argument on abuse of discretion is you didn't extend the deadline date for us to give a full, we would have submitted a bound and sealed appraisal by an independent expert. We would have given a fulsome description of Mr. L. Bogan's role at DTD Devco. We think what is here goes far enough, but that shouldn't be your inquiry, again, through the lens of deciding matters on the merits and weighing prejudice. There was no prejudice to this court saying, Hirsch, you done wrong, you trusted ADOT, they backflipped on you, they got you over, they got a sword of Damocles over your head. I will give you, I basically asked for like 60 days or 90 days to produce an appraisal and get your owner fully disclosed to put forth the case, and let's get going with this case. And I'm appreciative that the property owners, through its efforts, have eliminated all the issues except the single issue of the unit value of the part taken. But he didn't. He said, he didn't really make a Rule 6 type of issue, and that's another one of the points I raised because Your Honor raised it. If the court had held a hearing and said, I want to hear all about excusable neglect and Hirsch, your conduct and good cause shown, et cetera, and had denied it, we'd be up here on that basis. But that's not what happened. He didn't hear any of that. He said, I'm going to grant summary judgment. I'm going to keep this out no matter what happened. So we're here on the DeLong standard, which is different, which is through the lens of trying to get matters decided on the merits and on the weighing of prejudice. That's what this really comes down to.
Thank you,
I'm out of time. Thank you.
Thank you to counsel both for your oral presentations as well as your briefs. You've given us much to think of about, and we will take this matter under advisement, and we will issue a written decision in due course. Court stands in recess. Thank you.